Alright, Ohio Laws Administrative Rules Legislative Service Commission 1509-35 Oil Gas Commission. This is hereby created by the Oil Gas Commission, consisting of 5 members appointed by the governor terms of office over the 5 year commencing with the 15th day of the October, ending on the 14th day of the October, except for the term of the first 5 members of the board shall be 1, 2, or 3, or 4, or 5 years, respectively designated by the governor. Time of appointment. Each member shall hold the office of the day of the employment until the end of the term for which the member is appointed. A member appointed to fill vacancy occurring prior to the expiration of the term for which the member's predecessor was appointed shall hold the office for the remainder of the term. Any member shall continue with the office subsequent with the expiration date member term until the successor takes office until the period of 60 days of the lapse which occurs first. Each vacancy occurring on commission shall be filled with the appointment. Within 60 days after the vacancy occurs, one of the appointment of the commission shall be a person who, by reason of the previous location, employment affiliations, human class representative of the major petroleum company. One of the appointments commission shall be a person who, by reason of the person's previous vocation, employment, affiliations could be caused of the representative of the public. One of the appointees of the commission shall be the person reason of the previous training with experience can be class representative, independent petroleum operators. One of the appointments of the commission shall be a person of the reason by the previous training with experience can be class one learned and experienced oil gas law. But one of the appointment of the commission shall person who's by reason by a person previous training experience class and one learned experience geologically in petroleum engineering. No more than 3 members shall be members of the same political party, but the division does not apply with the temporary members appointed under Division C of the section. 3 members constitute a quorum. No action of the commission is valid unless with the concurrence of at least a majority of members voting on the action. Commission shall be kept record of proceedings. If the chairman of the commission determines the quorum cannot be obtained by the purpose of considering the matter of which will be before the commission because of the vacancy with the recusal of its members, chairman may contact the Technical Advisory Council of the Oil Gas Grid in Section 1509-38 with a revised code with the request a list of the members of council who may serve as the temporary members of the commission. And using the list by the council of the chairman may appoint temporary members of the commission. Appointment of the temporary members should be for only a matter whether the quorum can be obtained with a number of temporary members appointed by the chairperson shall not exceed the number of the necessary to obtain the quorum for the matter of the temporary matter of the commission have the same authority, rights, and obligations of member of the commission, including the right, compensation, other expenses provided in section authority, right, obligation, temporary member cease for the temporary member service of the commission ends. Each member shall pay an amount fixed pursuant to Division J of Section 124.15 Revised Code per diem would actually engage in performance of the work as a member will engage in travel the necessary connection with the work. This and such compensation each member shall be reimbursed for all traveling, hotel, other expenses necessary incurred with the performance of the work of the member. E. The commission shall select among its members a chairperson, vice chairperson, and a secretary of the office shall serve for terms of 1 year. The governor may remove any member of the commission for office deficient, neglect of the duty, malfeasance, misfeasance, and non-feasance. The commission, according to Chapter 119 Revised Code, shall adopt the rules to govern its procedures. Appeal to the Commission. Any person adversely affected by the order of the Chief of the Division of Oil Gas Resource Management may appeal to the Oil Gas Commission in order of vacating, modifying the order. Person appealing to the Commission shall know that the appealing with the Chief shall be known as the appealee, with the appealee when appellant shall be deemed to be the party to the appeal. With the appeal shall be written, set forth of the order, comply with the grounds of which of the appeal of the base of the appeal of the file with the Commission within 30 days of the date upon the person whom the order issued received the order with all the other persons adversely affected by the order 30 days for the day of the order commenced with the noticing of the file of appeal with the file with the chief for 3 days after the appeal with the file with the commission upon filing the appeal with the commission promptly fix the time and the place hearing with the appeal will be held with given the appeal within the chief of the latest 10 days written notice thereof. The mail of the commission may postpone with the continuing any hearing with its own motion upon an application of the appeal of the chief filing of an appeal provided that the section does not automatically suspend the state execution of other appeal from but upon an application for the appeal of the commission may suspend stay with execution pending a determination appeal upon such terms commission is considered proper. Either party of the appeal interested person who pursuant to the commission rules have granted permission to appear with the may submit such evidence as the commission considered admissible. For the purpose of conducting hearing on appeal, the commission may require the attendance for the witness production of the book, records, papers, and may with the request of any of the party shall issue subpoenas, written subpoenas, Deus tectum to compel with the production of any books and records, papers directly to the sheriff of the county with a witness or filing of the subpoenas shall be served and returned in the same manner as subpoenas in the criminal case are served and returned with the fees for the sheriff shall be the same as allowed for the court of common pleas in the criminal case. Witnesses shall be paid with the mileage provided under section 119094 revised code. Such mileage, fees and mileage expense incurred with the request for the appealant shall be paid in advance for the appealant, with the remainder of the expense for the shall be paid of all funds appropriated for the expense of the Division of Oil Gas Resource Management. In the case of disobedience, neglect of any subpoena served on any person or refusal of any witness testifying in a matter regarding the witness may be lawfully interrogated with the court of common plea for the county with the disobedience, neglect, or refusal occur with any of the judge thereof, the applicant over the commission, any member thereof shall compel obedience by attachment proceeding for contempt, casing disobedience of the requirements of the subpoena issued under the court refusal to testify therein. Witnesses such hearings shall testify under oath. Any member of the commission may administer the oath of affirmation to the person who shall testify. At the request of any of the party, the record of the testimony, other evidence shall be taken from the official reporter as expense of the party making the request of the record. Record shall include all the testimonies of the evidence revealing admissibility thereof. The presenting of the hearing of the commission shall pass with admissibility evidence put any party with the time the object of the commission of the evidence except ruling of the commission thereon. The commission refuses to admit the evidence of the party offering same. It may take part offer thereof and some proffer shall be made part of the record of the hearing. It's upon completion of the hearing the commission finds that the order of appeal was lawful and unreasonable. It shall be made an order affirming the order of appeal from. The commission finds the order was unreasonable, unlawful. It should be written in order vacating the order of appeal from the making of the order. Find the chief should have the made. Every order makes the commission shall contain a written finding with the commission of the facts upon which the order is based. Notice of the making of the order shall give the forthwith each party to appeal for the making certified copy. Therefore, each such party is by certified mail. Order commission is finally, unless vacated by the Court of Common Pleas, Franklin County, and appeal with the provided with section 150937 and with the revised code 150901 to 150937. Revised code provided with appeals relating to order chief by commission relating to the rules adopted by the chief that does not constitute the exclusive procedure of the person who believe the person right to be unlawfully affected by sections or any of the official actions taken there under the may pursue in order to protect the preserve of the rights, nor do the section constitute the procedure that a person must pursue before the person may be lawful appeal to the courts to protect and preserve the rights. Alright, 150937 appeal to common pleas. Any party adversely with the fact of the order in oil gas may appeal to the Court of Common Pleas of the Franklin County, and part of the desiring to do so with appeal will file with the commission with the notice of appealing is gave the order of the appeal from and instead of the way of the appeal is taken. No question of the law, with the question of the law, and with the fact that the copy of the notice shall be filed with the applicant with the court of the shall be paid mailed with the otherwise deliberately appeal with such notice shall be filed with the mail otherwise delivered with 30 days of the day of the time of the appeal and received with a notice of commission certified mail making the order appeal with no appeal that shall be required to make an appeal with the question of the law of the appeal of the question of the law in fact effective. Following notice of the appeal shall be not automatically operate with the suspension of the order of the commission appear with the court with the unjust hardship of the appeal with the result of the execution of the commission order pending determination of the appeal of the court may grant suspension of the order to fix its terms within the 15-day receipt with the notice of the appeal of the commission shall prepare with the file of the court complete with the record proceeding out with the appeal arrived including transaction testimony evidence submitted before the commission expend with the preparing transcribing the record should be the tax part of the cost of the appeal with the appealant shall be provided with the security for the cost satisfactory to the court upon demand by party of the commission shall furnish the cost of the party and request for the same copy of the record with the copy of the record now filed with the court within the time provided with the section. Either party may apply to the court to have the case docketed if the court shall order such record filed. In hearing of the appeal court confined with the record certified by the commission, the court may request an admission of additional evidence if it is satisfied with additional evidence newly discovered that could not be with reasonable diligence evidence asserted prior to the hearing of before the commission. The court shall conduct the hearing on appeal with the given preference of the hearing of all over their civil cases irrespectively of the position and proceeding of the calendar of the court. Hearing of the court shall proceed as a trial of civil action, and the court shall determine with the rights of the parties according to the laws applicable to such action. That hearing counsel for the hear oral argument briefs with may be submitted with the evidence introduced. The court granted the request for the presentation of additional evidence. If the court finds the order commission appeal with lawful reasonable, it shall affirm the order. If the court finds that the order was unreasonable and unlawful, shall vacate the order and make the order. With the commission shall have made with the judgment of the court and final unless the reverse vacated or modified on an appeal. 150938 Technical Advisory Council. They hereby created by the Division of Oil, Gas, Resource Management. The Technical Advisory Council on Oil and Gas shall consist of the 8 members of the appointed with the government with the advice of the consent of the members of the independent of the oil and gas producers, operators, and the representative of the operating producer, primarily in the shape of the 3 members of oil gas producers, the operators, and the representatives have substantial oil gas producing operations state, at least one of other state. 1 member shall represent the public. 1 member shall represent the person having the landowner royalty interest in oil and gas production. All members shall be resident of the state, with all members except for the members president and with the representative of the public and person in the landowner royalty interest shall have at least 5 years practical technical experience in oil, gas drilling, and production. No more than 1 member may represent any one company, producer, and operator. Terms of office for this shall be 3 years, commencing first day of the February, ending with the 31st day of the January. Each member shall hold the office from the day of the appointment and end of the term of the appointment member was appointed. A vacancy of the office of the member shall be filed with the governor with the advice of the consent of the Senate, with any member appointed with the fill the vacancy occurring with the expiration of the term which member's predecessor was appointed shall officer should hold the office for the remainder of the term. Any member shall continue the office subsequent to the expiration date. Members' terms until the member successfully takes office for the end of the period of 60 days elapsed, whichever occurs first. The council select among the members of the chairperson, vice chairperson, all members entitled to the actual necessary expense for the incurred for the performance of the duties and members payable for the operation of the division. Government may remove any member inefficiency, neglect duty, and malefacence in office. Council shall hold at least 1 regular meeting in each quarter calendar year. Shall keep the record of this proceeding. Special meetings may be called with the chairperson. Shall be called by the chairperson upon receipt of a written request signed by the 2 or more members of the council. Written notice for the time and the place of the meeting shall be sent to each of the member of the council. 5 members constitute with a quorum. No action council is valid unless 5 members occur. Council's request for the chief of the division of oil, gas, resource management should consult with and advise the chief of the perform other duties if it would be lawfully delegated to the chief. The council shall participate in hearings hereby with the chief on the chapter powers of approval as provided in section 1509, 24, and 25 of Revised Code. Council should conduct the activities required to exercise the authority granted under section 1510 of the Revised Code. Council, upon receipt of the request, the chairperson of the Oil Gas Commission under Subdivision C of the section 1509-35 of Revised Code immediately shall prepare and provide chairperson list of the members who serve as temporary members of the Oil and Gas Commission as provided in this division. 1509-40 Limitation of production. Except as provided in 1509-29 Revised Statute, no authority granted within this chapter should be construed as authorization to limitation on the amount of any well leaseholder field permitted to produce under proration orders of the Division of Oil, Gas, Resource Management. Antitrust violation. No combination of the person interest authorized provision 1509 Revised Code should construe with the trust, monopoly, or other combination restraint with a trade prohibited by law. 1950 Oil Gas Regulatory Cost Recovery Assessment. An oil gas regulatory cost recovery assessment is hereby imposed by the section of the owner, and the owner shall pay with the assessment of the same manner as the server is required with the file determined as section 574906. Revised Code have the owner may designate a server who pays the owner for the assessment behalf of the owner return the server that does require file under the section. Server is over the pay owner's assessment. Server may recoup the amount of the own amount of assessment except for the domestic well assessment imposed shall with additional tax levied on the severance for the oil and gas under section 574902 of the Revised Code, except for the exempt domestic well of the oil and gas regulatory recovery assessment shall be calculated on a quarterly basis as follows: 1/2, 1,000 cubic feet of the natural gas as wells of the owner, 10 cents per barrel of oil or wells for the other owners. All money collected pursuant to the section shall be credited with the severance tax receipt fund. After the director of the budget management transfer the money with the severance tax receipt fund, it is required in Division 8, section 57 574906 Revised Code. Money surveillance tax recipients found from the fund from the amounts all collected pursuant to the section shall be credited with the oil gas well fund created in 150902 Revised Code. So for the purpose of revenue distribution specified in Division B 574902 Revised Code, the oil gas regulatory cost recovery assessment imposed by the section shall be treated the same and equivalent of all purposes as tax levied on severance of the oil and gas under that section. However, the assessment imposed by the section is not a tax. Chapter 5749 of the Revised Code. 150960, notice of filing a permanent drilling a new well. If the owner and parcel of the real property receive the notice of the concern filing an application to permit the drilling of the new well with the urbanized area that is required in subdivision A9 in section 150906 Revised Code, owner shall provide each resident of the occupied dwelling is located on the owner parcel of the real property copy of the notice of the 5 days receipt of the notice. Public meeting required concerning proposed lease agreements for the development of oil and gas resource 150961. Legislative authority political subdivision conduct of the public meeting concerning the proposed lease agreement of the development of oil and gas resource for the land is located with the owner in an urbanized area with the owner with the political subdivision prior entering the lease agreement. The public meeting should conduct for the public venue of the public municipal corporation township with the proposed well with the located public meeting shall not occur with the same meeting with the legislative authority public subdivision votes entering in the proposed lease if applicable. Legislative authority of public subdivision shall notice of not later than 10 days but the day of the public meeting with the owner each parcel of the real property located within 500 feet with the surface location of the property with the subject of the proposed lease agreement. Notice shall contain the statement of the legislative authority public subdivision considering entering the oil and gas lease agreement and provided with the location, date, and the time of the public meeting. Additional statement shall contain the statement of the informed owner and real property required for the receipt of the notice of the public meeting under the division of the 5 days receipt of the notice of the owner is required to provide under Division C of Section each resident or occupied dwelling located with the owner parcel of the real property. Legislative authority over the public subdivision required to provide notice under Division A of the section provided with the notice according to the requirements established by the legislative authority governing public meetings that are held by the legislative authority. See if the owner and parcel of the real property receive a notice under the Division A section of the owner shall provide each resident within an occupied dwelling located with the owned parcel of the real property and a copy of the notice of 5 days receipt of the notice. 1509.99 penalty. Whenever the violation 1509 through 5931 of the revised code, any rules adopted that order, term, and condition permanent issue pursuant to the section, no specific penalties provided in section shall be fined no less than $100, no more than $1,000 for your first offense. For each subsequent offense of the person the person shall be fined no less than $200, no more than $2,000. Who violates 1509-221 revised code rules adopted in order, terms, condition, permit issued thereunder shall fine no more than $5,000 each violation. See, where knowingly violates 1509-072 Division A, B, or D of Section 1509-22 Division A, 1, or C, Section 1509-222, or Division A or D of Section 1509-223 revised code. Any rules adopted with the order issued under Division C 1509-22, rules adopted, orders, terms, condition, registration certificate issued under Division E section 1509-222. Revised code should be defined $10,000 imposed 6 months over the both first offense. Subsequent offense of the person shall fine $20,000 in prison with 2 years or both of negligent violates the division section rules, order, terms, condition, registered certificate shall fine no more than $5,000. Whoever violates Division C of Section 1509-223 with the revised code shall fine no more than $500 for the first offense, no more than $1,000 as a subsequent offense. Prosecuting attorney of the county which offense was committed to the Attorney General may prosecute any action under this section. And for the purpose of the section, each day violation constitutes a separate offense. And that completes, that completes Division Oil, Gas, Resource Management, Oil and Gas Office, Ohio Laws and Administrative Rules on the Oil Commission in this tape, which started at 1509.35 through 1509.99.